Hello everyone, and welcome back. Today, we're diving into the wonderfully weird world of American justice, a place where people have actually sued over hot coffee, haunted houses, and even bad karaoke. These are the 50 dumbest court cases that somehow created real, legally binding laws. Imagine living in a country where dropping a slice of cheese could end up before a judge. In Law Number 6, one man's fast food disaster turned into a national debate. Law Number 18. That one involves a burglar suing the homeowners he was robbing. And, wait, until you hear Law Number 42, it's so bizarre. Even the lawyers laughed in court. So grab your popcorn, your legal pad, and maybe a helmet, because we're about to witness America's most absurd moments of courtroom creativity. And hey, before we proceed, hit that subscribe button, or the judge might hold you in contempt of entertainment. 1. Lebec v. McDonald's Restaurants, 1994. The hot coffee burn-it all started in New Mexico when Stella Lebec spilled scalding McDonald's coffee on her lap. The coffee was so hot, it caused third-degree burns. She sued and won. The case sparked national outrage, turning frivolous lawsuit into a household phrase. But here's the twist. McDonald's had been warned over 700 times about the same issue, so technically, Stella wasn't crazy, just extremely unlucky. The law that followed, companies began labeling everything from cups to kettles with caution. Hot. Now, even your coffee mug assumes you might drink with your knees, too. The missing pants. Case A, Washington, D.C. Judge sued his dry cleaner for $67 million over a pair of lost pants. He claimed emotional distress. The case dragged on for years before being dismissed, but not before teaching lawmakers a valuable lesson about tort reform. The aftermath. Satisfaction guaranteed signs started disappearing from shops across the country. Imagine having to prove in court that your trousers were worth more than a Lamborghini. 3. Eavesdropping friend. An Illinois man reported a coworker for eavesdropping and got fired. He sued the company and the court sided with him, creating new protections for whistleblowers. Basically, one office snitch changed U.S. employment law so the next time your coworker whispers, don't tell anyone. Remember, it could become a Supreme Court issue. 4. Overton v. State of Ohio, 1972. The drunk horse case in Ohio. A man was arrested for riding his horse while intoxicated. He argued the law applied only to cars. The court disagreed. This single case inspired state laws treating horses as vehicles under DUI rules. Picture a sheriff chasing a galloping cowboy shouting, "Pull over," by order of the law. Somewhere, a horse is still waiting for its breathalyzer results. 5. United States v. 40 barrels and 20 kegs of Coca-Cola, 1916. The caffeine crisis. Yes, the government literally sued Coca-Cola, not the company, but the product itself. They argued it was adulterated with caffeine, ruled caffeine wasn't poisonous, but Coke did reduce its caffeine levels. That trial gave birth to labeling laws for food and drinks. So, technically, your energy drink warning label exists because someone once put Coca-Cola on trial for being too fun. 6. The Burger King cheese case, 2009. Florida man sued Burger King because his double cheeseburger had only one slice of cheese. He said it violated truth in advertising. The court threw it out faster than a cold fry. But the story spread, and now fast food chains must display visual representations, only disclaimers on menus. Imagine being the guy whose legacy is, he fought for extra cheese. And justice was served. 7. Harris v. Time Inc., 1987. The free watch fiasco. Amon received a mailer promising a free watch if he opened the envelope. He did. Inside was just a magazine subscription offer. So, he sued. The court ruled the mailer was misleading, and Time Inc. paid up. This case shaped modern consumer protection laws. Every terms and conditions apply. Warning, UC Today owes its existence to one disappointed man and a missing watch. 8. The haunted house case, Stambovsky v. Ackley, 1991. New York homebuyer discovered his new house was famous for being haunted. He sued the seller for not disclosing its ghostly reputation. The judge sided with him, declaring, as a matter of law, the house is haunted. This surreal ruling set a precedent for real estate disclosure laws. So, if your attic whispers at night, better list it under amenities. 9. Boring v. Google Inc., 2008. The Street View, Sneak, Pennsylvania couple sued Google after a Street View car photographed their private driveway. They won a tiny settlement, but but it sparked nationwide debates on digital privacy. Now, every blurry house on Google Maps exists thanks to this case. Somewhere, a couple is sipping coffee proudly saying, "We're the reason your house looks like Bigfoot's summer home." 10. Miller v. California 1973. The obscenity dilemma. This California case redefined what obscenity means in U.S. law. Miller mailed adult materials to unwilling recipients, sparking a national fight over free speech. The Supreme Court created the Miller test to decide what counts as obscene. It's why movies, art, and comedy must now pass a three-part test before being labeled too explicit. In short, one man's bad mail habits rewrote America's moral code and ruined the postal workers. 11. Fisher v. Lowe, 1983. The flying Chevy case in Michigan. A man's car hit a tree, and a huge branch fell onto a photographer taking pictures nearby. The photographer sued for damages. The twist: the judge dismissed it using a rhyme. He wrote the entire ruling as a poem, ending with, "We find for the defendant." And so it's done. Case closed. This whimsical decision became a teaching example in law schools, proving even judges get bored. Thanks to Fisher v. Lowe, poetic rulings are technically legal, though not encouraged. 12. The Winnebago Cruise Control Case, 2001. The myth that became lay driver set his RV's cruise control and walked to make coffee. He crashed, of course, and sued Winnebago for not warning him. Though this case is partly mythologized, it led many RV manufacturers to add explicit warnings, like, "Cruise control does not steer vehicle." It's a rare moment when humanity collectively realized common sense needed legal backup. 13. People v. Kellogg, 2004. The sleepwalking crime in San Diego. A homeless man with a history of sleepwalking wandered into someone's garage and fell asleep. He was charged with trespassing. The court eventually ruled his sleep disorder was a medical condition, not a crime. This case changed how courts treat involuntary actions. So now, if you commit a crime in your sleep, you might just get a doctor instead of a cell. 14. The monkey selfie case, 2015. California photographer set up his camera in Indonesia. A monkey pressed the shutter button and took a now famous selfie. PETA sued on behalf of the monkey, claiming copyright. The judge ruled that animals can't own copyrights. That one decision shaped all digital copyright law regarding non-human creators. So yes, a selfie-loving monkey helped define modern intellectual property. Try explaining that to your lawyer. 15. The literary revolution. James Joyce's Ulysses was once banned in the U.S. for being obscene. A court finally ruled it was art, not smut, freeing literature from censorship laws. The case redefined artistic freedom and led to more open publishing standards. In short, one long, confusing novel made it legal for authors to be weird. 16. Widow sued tobacco companies, arguing they knew cigarettes were deadly and hid the evidence. The court sided with her, forcing the release of millions of secret documents. This landmark case birthed the modern warning label, "Smoking causes lung cancer." It also showed that sometimes a dumb lawsuit turns out to be society's wake-up call, literally printed on every cigarette box. 17. 1984. The loud music defense. A man in California was arrested for blasting rock music so loud it rattled the whole block. He argued it was freedom of expression. The court didn't buy it, but the case led cities to define acceptable noise levels and time limits. So now, your 3 a.m. karaoke isn't just annoying, it's regulated by case law. Somewhere, a drummer still claims he was silenced by the man. 18. Catco v. Briney, 1971. The shotgun trap case. A farmer, tired of burglars, rigged a spring-loaded shotgun to fire when someone opened his door. A burglar got injured and sued. Shockingly, the burglar won. The court ruled you can't use deadly force to protect unoccupied property. It's the case that redefined self-defense laws across America. So yes, a thief once got paid for getting shot, and lawyers still bring it up in ethics. Class with deep size. 19. United States v. 95. Barrels of vinegar. 1924. The misleading label law. The government literally seized barrels of vinegar for false advertising. They were labeled apple cider vinegar, but made mostly from dried apple products. The court ruled in favor of accuracy, giving birth to modern food labeling standards. So every time you read contains natural flavors, you can thank a century-old vinegar scandal. 20. State of Iowa v. Hodges, 1980. The exploding toilet. Man's illegal fireworks stash accidentally blew up his bathroom. He sued the manufacturer, claiming the firecrackers didn't have adequate warnings. The case was dismissed, but it inspired lawmakers to strengthen product safety disclaimers. Now, fireworks packaging practically screams, "Don't light near flammable objects," thanks to one unfortunate bathroom break gone nuclear. 21. Morse v. Frederick 2007. Bong hits for Jesus during a school parade in Alaska. A student held a banner reading "Bong hits for Jesus." The principal suspended him, and he sued for violating free speech. The Supreme Court ruled schools can restrict pro-drug messages on campus. It set a national precedent for student speech rights and a permanent spot for the phrase "Bong hits for Jesus" in legal history. Some lawyers still can't say it without giggling, and man saw a Pepsi commercial joking that 7 million Pepsi points could buy a Harrier jet. He collected points and demanded the jet. The court said no reasonable person would think the offer real, but the case forced companies to clarify fine print in ads. Now every commercial says dramatization only, because one guy tried to trade soda caps for military hardware. 23-1961. Federal inspectors found unsanitary meat at a restaurant. Instead of charging the owner, they literally sued the meat. The court condemned the barbecue and ordered it destroyed. This odd case cemented the idea that objects can be defendants in public health cases. Somewhere in legal heaven, a slab of ribs still pleads not guilty. 24. State v. Loomis, 2016. The algorithm judge in Wisconsin. A judge used a secret algorithm to help sentence a man. Loomis argued it was unfair because no one knew how the program worked. The court upheld the sentence, but warned against blindly trusting AI and justice. That one decision sparked a national conversation about algorithms and bias. Yes, the U.S. legal system once said the computer told me so. 25. Doctor ordered contraceptives from Japan for medical research. Customs seized them as obscene material. The court ruled medical professionals could import them legally, paving the way for birth control reform. The title remains one of the most awkward case names ever printed in law books. The judge reportedly blushed while reading it. Man needed a bone marrow donation from his cousin, who refused. He sued to force him to donate. The court sympathized, but ruled no one can be legally compelled to give up body parts. It became a key medical ethics precedent. So, if your family refuses to share fries, just remember, the law is on their side. The case of the burning beard, 1985. California man sued a barber after his beard caught fire during a hot towel treatment. He won a small settlement, and barbershops began adding safety rules for heat tools. That's why you see flammable products near open flame warnings in salons today. Some laws exist because a man couldn't keep his chin cool. 12-year-old girl was arrested in Washington, D.C. for eating a French fry on the subway. Zero tolerance policy. The judge criticized the rule as absurd, and it was later relaxed. This tiny incident reshaped juvenile enforcement laws. Somewhere, a French fry became a symbol of civil liberties. Crispy, golden, and briefly detained. The marriage shift. California's Prop 8 banned same-sex marriage. After years of court battles, the Supreme Court dismissed the ban for lack of standing. This paved the way for nationwide marriage equality. A case that started with technicalities ended as a civil rights milestone. It's a reminder that even a boring procedural error can change history. Case of the couch potato break-in. 2007. Oregon burglar broke into a house, ate snacks, and fell asleep on the sofa. When caught, he sued for emotional trauma after the owner shouted at him. The court laughed it out of existence, but it helped define frivolous lawsuit criteria. So yes, a man once broke in, napped, and tried to bill the victims for hurt feelings. A federal judge ruled the ban unconstitutional, protecting literature from local censorship. It confirmed that being offended isn't a reason to confiscate art. Thanks to this case, school boards everywhere still argue about novels, but at least now they have to read them first. Reproductive rights were mostly Jane Roe challenged Texas laws, and the Supreme Court declared privacy a constitutional right. Whatever side of the debate people fall on, the case reshaped American law, culture, and politics. It showed how a single lawsuit can divide dinner tables for half a century. 33. The cereal box toy. Case 1955. After a child swallowed a tiny prize from a cereal box, his parents sued the cereal maker. They lost, but the FDA introduced new toy safety safety rules. That's why today's cereal prizes are either huge or gone entirely. One kid's bad breakfast ended an era of plastic dinosaurs between your cornflakes. 34. State of Florida v. Easter Bunny, 1978. Okay, not literally the bunny, but a man dressed as one was arrested for handing out eggs without a permit. He sued, claiming religious expression. The case was tossed, but cities revised their parade permit laws to clarify mascots count as performers. So yes, someone once fought for the Easter Bunny's First Amendment rights. The case of the flying cows, 1976. Texas A rancher sued an airline when low-flying jets frightened his cattle, causing them to stampede through fences. The court ruled in his favor, forcing airports to monitor flight path noise. This gave birth to modern air nuisance laws. Somewhere, a cow probably earned frequent flyer miles that day. 36 people. V. Davis, 1982. The dumpster diamond case. A man was charged with theft for taking jewelry he found in a trash can. The court decided that once something's discarded, it's no longer property. This ruling created what we now call the dumpster diving defense. So yes, modern recyclers can thank a man who literally went treasure hunting behind a mall. Commonwealth v. Sexton, 1988. The lawnmower DUI in Pennsylvania. A man was arrested for driving drunk on a riding mower. He argued it wasn't a vehicle. The court disagreed, creating one of the strangest DUI precedents in history. That's why your state DMV now clarifies, if it has wheels and a motor, it counts. Lawn care equals law care. 38. The caffeinated parrot. Florida woman's parrot screamed profanities so loudly it violated a noise ordinance. She argued the bird was exercising free speech. The judge disagreed, but reduced the fine. The city later rewrote its law to exclude non-human vocal sources. That's right, an angry parrot forced lawmakers to define. Speaker. 39. The Red Bull settlement, 2014. Consumers sued Red Bull for false advertising after realizing it didn't actually give them wings. The company settled for millions, proving sarcasm can be legally binding. This is why modern commercials say things like, figuratively speaking, 1. Energy drink joke turned into a national grammar. 40. Hollerman v. United States, 1950. The Snowball Ban Law was fined for throwing snowballs in a city park. He argued it was a form of recreation, not vandalism. The court sided with him, prompting cities to rewrite winter activity rules. Now, snowball fights are technically allowed in many towns, just not at City Hall. The book about nothing. Case. A humor writer sued comedian Jerry Seinfeld's wife for plagiarizing his cookbook idea. The judge dismissed it, noting no one owns the idea of being funny about recipes. It's the lawsuit about nothing fitting for the Seinfeld universe. The real takeaway? You can copyright text, but not wit. The beer and alligator case, 2011. Louisiana man got drunk, decided to wrestle an alligator, and lost a hand. He sued the park for failing to post warning signs. The judge ruled against him, but required future parks to display clear safety warnings. So now, don't feed or touch the alligators exists because one man confused beer courage with legal logic. 43. Government seized pies for mislabeling ingredients. The court's opinion ran longer than most cookbooks. This sweet but sticky case, refined. Labeling accuracy rules for bakeries nationwide. One could say justice was served. The flying squirrel smuggling ring. A man tried to sneak flying squirrels out of Florida in his car's spare tire compartment. When caught, he claimed they were emotional support rodents. The case prompted new wildlife transport regulations. The moral, if your therapy animal can glide, maybe drive slower. The U.S. actually sued the shark fins. They were confiscated for illegal harvesting. The court ordered their destruction, reinforcing environmental enforcement laws. It's one of the few times justice was served in bulk. 46. The case of the exploding toilet, revisited, 2013. New Jersey. A hotel guest sat down, and the toilet exploded from a plumbing malfunction. He sued for emotional distress and won. Now, hotels must post-maintenance inspection. Every safe flush today owes thanks to a man whose morning routine went catastrophically wrong. Baseball player was hit in the face by a pitch during a college game and sued the opposing team for failing to warn him. The court ruled getting hit is part of the game, setting a sports injury precedent still cited today. It's the legal version of play stupid games. Wins settled claims. 48. The subway footlong Lawsuit. 2013 customers discovered Subway's footlong sandwiches sometimes measured only 11 inches. They sued. The class action was settled, and Subway promised consistency. Measuring rules were added to fast food advertising nationwide. Somewhere, a ruler became a courtroom exhibit. Proving size really does matter, at least in marketing. The slavery allegation PTA sued arguing orcas were held as slaves under the 13th Amendment. The judge dismissed it, stating the Constitution doesn't apply to animals, though thrown out. The case boosted global debate on animal rights and captivity laws. Sometimes even losing cases make waves. Literally. 50. The case of the burglar and the skylight. 1982 California burglar fell through a skylight while robbing a school, injured himself, and sued the district, and won a settlement. The outrage that followed led to stricter laws against frivolous lawsuits. This case remains the poster child for why we can't have nice things. It's the final proof that in American law, even criminals occasionally get lucky. Breaks usually through the ceiling. And that wraps up our legal circus 50 real-life court cases that prove the system can be both brilliant and bewildering. From haunted houses to hot coffee, from monkeys with copyrights to sandwiches on trial, each one left a strange little footprint in the history of American law. If there's one lesson here, it's this: common sense might not always win in court, but it definitely needs better lawyers. Maybe next time we discuss 50 bizarre laws about animals that somehow still exist. Or perhaps we'll dive into 50 ridiculous food regulations that make you question reality. Until then, hit like, subscribe, and tell me which case left you speechless or laughing. And remember, if you ever think your life is weird, at least you've never had to sue over a sandwich.